you. As Filipe has said, I will speak in Portuguese, and so I will start immediately, and I'll try to be quite brief.
Well, I think in order to understand the lines of action in future of the EU in terms of rule of law, and please bear in mind that when we speak of rule of law, we're not talking only about our special attention to judicial independence and autonomy of the prosecutor's office, but when you're talking about this, we're talking about the respect for the fundamental rights in general. So we're talking about a much broader thing, and that is very clear in the case of Hungary, in which what is in question is the freedom of investigation. What is in question because of the George Soros and the European Central University. What is in question both in Poland and Hungary, the rights of sexual minorities. What is in question is, in the case of Hungary, particularly the state of emergency during the pandemic. So just to say that obviously the rule of law goes beyond judicial independence, even though it is extremely important. Curiously, in the two most known cases, but they're not the only ones, which are Hungary and Poland, judicial independence is there right from the beginning. In the case of Hungary, with the cases that have already been heard of 2012, with the constitutional reform and the new constitution, what happened was we had that compulsory reform of compulsory retirement in 2012 of the judges who were 62 years old. The idea was a cleansing and open up a set of vacancies to appoint a new judge according to new criteria, because in the meantime, the National Council Justice had the office and was separated. And it was only one person that really decided and took important decisions. And in the case of Poland, even though now we have many issues, as we know, with the disciplinary community, the Supreme Court, etc., everything started in 2017 with questions connected, namely to the Constitutional Court and the way it was elected, etc. So judicial independence is here in the European issues everywhere. And also in the case of Spain, where the European Commission has warned about this question, about the General Council of Judicial Power. We heard this right at the end now of this crossroads, and also the method used, and the same thing for the indication for the Constitutional Court, and also in the Spanish case, even though it's not very different from others, as I had political resonance and partisan that's much stronger than in other countries. So that is one aspect. But, for example, it's also good for Malta. We never hear of Malta. With the case of the assassination of the journalist, there was a report by 3 judges that had already been withdrawn, and they had a commission and said that the government was responsible for this assassination, and a council of ministers collectively with a set of missions, and some of those missions, and one of the inactions was the interference in the investigation, direct interference in the investigation, namely through the police forces, in the case of Malta, Slovakia, Romania, with corruption as well. In all of them, we have criminal investigation always at stake. I could give an example. Denmark, that's always considered a big representative of rule of law. In this question of migrants, that confiscation of the personal assets of migrants, jewels, jewelry, and phones to pay expenses, this is contrary to the dignity of humans. So it's these are things that would be worthy to mention. It's not isolating the most serious cases because they're institutional of Hungary and Poland, but we need to mention this. But what I wanted to say here, these cases, this rule of law has this broad sense, and what the EU has at its availability, at its disposal, is that it has not worked the best way. The Hungarian case is the most exemplary one, because if it had been stopped in the beginning, and it could have been stopped, and at that time the Hungarian authorities and the Prime Minister Viktor Orban were available for that, because they stepped back a few times in this question of compulsory retirement. They were forced to step back, and they did. In that stage, it was easy, with adequate political pressure, to be able to avoid the path that was then taken. But what are the mechanisms that exist? The most known mechanism is the mechanism of Article 7 of the Treaty of the EU, that basically foresees preventive measures. The first preventive measures are deep down, can be adopted by 4/5, and it's to verify that there is a serious risk of the violation of the essential values of the EU, the values of the Article 2 of the treaty, basically that. And there, I would like to say something, because all of them, including the Portuguese government, the Prime Minister has said this several times, because we wouldn't activate Article 7 because we needed unanimity, and that's false. This first stage, the preventive stage, which is the very first one, and through which we have to go to move on to sanctions, demands 4/5 only. So it is something that was perfectly, even with the objection of one state, for example, of Poland in the case of Hungary, or Poland in the case of Hungary. And there we have the probability to check that there was a violation, but then decreeing sanctions is not by unanimity. So it's just to say that this is not insusceptible of being used, as the Council has always said. So on one side we have Article 7, it's a mechanism that we have. Another one that is very important and which has been used the most, and quite honestly, when I say in the beginning of the Hungarian case, with a lot of interest and positive effects, because there were several steps back, but in the meantime, without any effect, or the process of breach, then they go to the Court of Justice, and it condemns the state on certain actions, and if they don't comply, then can go to the Court of Justice again through the Commission to decree the sanctions. For example, this moment, that's what's happening in Poland, because it didn't comply with one of the decisions of the European Court and must pay 1 million euros per day. So it's like a compulsory fine. It's an affront to force the state into compliance. So we have these cases of breach, and we've seen in the LGTBI rights, the cases of the university, and pluralism of the media. In the Hungarian case, it's also been debated a lot, and now we've spoken about this in the Slovenian case. We have seen cases of breach. So these are surgical cases that go to the Court of Justice, and if the decision is not executed, there are ways of enforcing its execution. So this has been the most used mediums, and I must say that the Commission did not act at then. But then with the Vivian Commission opened up several cases of breach, and all of them had some success, because the Hungarian government always stepped back in some places. It doesn't mean that it took 2 steps forward and 1 back only, but they stopped going back as from 2015, 2016. And this has a political reading. It's important to understand that the election of Donald Trump in the United States changed completely the behavior of Poland and Hungary in this field. In other words, they felt that they were protected, so they felt comforted in this process to be able to take even further this divorce from the rule of law. First, Article 7, and then the breach cases. And now there is a third way that, quite honestly, is the one where we sometimes see this Spanish issue coming up for the first time, which is a report that the Commission has of the situation of rule of law in the 27 countries. It's not what we wanted, and I'll talk about that. That's why when we talk about the future, we'll talk about that. But at this moment, the Commission has an annual report, this von der Leyen Commission, on the situation of the rule of law. and has a monitoring of the 27 countries and carrying out recommendations and appreciations. And in spite of that, the report has some limitations because it's very much focused on the information that the actual state gives. Even though we have NGOs that are being consulted and other sources for the report, but it has some limitations. In any case, it has a very big advantage, which is putting the 27 countries under monitoring. Because one of the problems that the states like Hungary and Poland complain about and make themselves victims, they look at us, they don't look at others. The Hungarians showed very well that the mass media law and the regulatory body for the media is taken from the Portuguese model. The electoral system was very much contested and is more proportional and more open than the English one, they would say. So let's say there is a persecution here. Obviously, this argument can be dealt away with. But the fact that the 27 are under an examination which is impartial and systematic avoids that when we have a very serious abnormality in one of the states, this is not a persecution to that state because they were all subject to the same scrutiny. And then finally, what is now in force, and it is on this mechanism that I would like to talk about, is the conditionality regarding funds. As you know, when they decided to have this this next generation EU in July 2020, it was agreed that there would be a conditionality of the rule of law. Only if the principle of rule of law was complied with would there be the concession of funds, so funds would not be attributed if this was not complied. This same prerequisite was demanded by the European Parliament. The European Parliament, when they vote for the authorization for their own funds, which is what makes possible to go to the markets later on, when they make that vote, conditioned the favorable vote so that the Commission and they would accept this mechanism of conditionality. In other words, funds are only attributed to the countries if they have a compliance of the rule of law. And then as from there, we have a regulation precisely for that. The regulation has a limitation. The violations of rule of law must put into question the good management of the financial resources. In other words, there's a connection. These are violations that will put into question, in a way, the guarantee that exists that the financial interests of the Union are not harmed. So they have this limitation. This regulation was approved. It was approved in December of 2020, when precisely Hungary and Poland, because every state, just like the European Parliament, must authorize this decision of own resources. They said we're not going to authorize going to the market. Our parliaments are not going to do that if this regulation comes into force. So what was agreed, the consensus that Chancellor Merkel, now out of office, was the great negotiator, was as follows. We are going to condition the concession of funds not only in the next generation EU, not only in the RRP, also for the pluriannual financial framework, will be conditioned to the compliance of criteria of rule of law. In other words, states that don't comply with them will see their funds suspended or don't even receive them if it's right in the beginning. So this was decided, but there's going to be a lag de facto for Poland and Hungary because they are going to attack the regulation in the Court of Justice of the EU, and only when they issue their final judgment, then we apply the regulation. This is a kind of a gentleman's agreement. So it was an agreement in parallel, and in spite of this conditionality having come into force on the 1st of January, the Commission has not applied it yet because it's waiting for the justice to pronounce itself. So we have seen that this mechanism of conditionality only for funds is completely in line with the European treaties. There's absolutely no problem, but we still need the final decision of the Court of Justice, and it can actually be different without the conclusions of the general judges, but that might not happen. So at this moment, what is happening is that the truth is one. In spite of the in spite of the Commission refusing to apply the regulation, it is waiting for that moratorium with this parallel agreement. In the meantime, the European Parliament has already put the Commission in court because it's not applying the regulation. So we also have a parallel case running. But what is interesting here to see is that the Commission has not approved yet the plans, nor from Poland, nor from Hungary. So it is playing this game over here. In other words, in fact, it's not applying the regulation and should be, but the truth is that it has not approved the plans. So no Poland, no Hungary are receiving funds from the next generation EU. So we have a palette of 4 instruments, Article 7, that we can call it a way of suspending the right to vote in the Council. Then we have the report. We have the normal breach cases. For example, if a state does not comply with a directive, does not translate it within the deadline. So these are normal cases, but they must be applied to all these issues. So we have a few dozen of them over the last 10 years, and then related with the rule of law or subjects the rule of law. And then we have this mechanism of conditionality. Now, what did I wanted to leave you with and conclusions that don't take so long? So to talk to you about the framework that we have. What is failing here and what are the 2 lines that I think in the future should be developed? I'm not saying that there are, I'm saying that they should be. Both the Commission and the Parliament, but especially the Parliament, have always wanted to create a kind of European mechanism of control of the compliance of the rule of law. Because there were so many breaches, and we see those breaches in the case of Hungary and Poland very strongly. Why are Hungary and Poland more serious? Because in other places, the rules are according to the rule of law, but the practices are not. But in the case of Hungary and Poland, the practices started by not being according to the rule of law, but then they changed the rules to make those practices adequate. And it's more serious. Why? Because they changed the actual institutions and made changes of the juridical order, and they themselves are against the rule of law. So they're not limited to what in Malta, the rules of the Maltese state accept a little bit of the government and the prosecutors, but the rules were according to a rule of law, but then the practice in the government was not, which is something totally different. It's a breach, of course, but in this case, not only was the practice contrary, but then the governments and parliaments started changing the laws precisely to have practices against the rule of law. A short while ago, the Polish judge said that the appointments were done according to the law, but the law is not according to the Constitution, so there was a legal change contrary to the principle of rule of law. What needs to be done? First, from my point of view, which is essential, is to create a control mechanism of the rule of law. It's a kind of European semester, just like the European semester for the economic and financial issues. We have this monitoring. It's not this report only that the Commission is doing. It's really a mechanism of conditionality with sanctions foreseen that can imply funds or fines and perhaps other kinds of legal consequences. But deep down, we needed to have a mechanism only guided towards rule of law and a legal mechanism in terms of procedure that is applied to all 27 member states. And then, of course, naturally, in some cases can be only surgical, in other cases can have more systemic consequences for that state depending on the degree of severity. And then the second point that I wanted to draw to your attention is exclusively political for the future. I'd like to explain the following. Article 7 was activated by the Commission against Poland in December 2017 and by the Parliament against Hungary in September 2018. And the Council did absolutely nothing. So the Council received Article 7, the activation, and pure and simply did nothing. always with the argument of unanimity, and I say it's false. At least for the first stage of the case, all we need is 4/5 of the states, and it was always making some time. And now in June there was an audition, but it's just to make believe, because we actually heard that they weren't very concerned with the rule of state, and for example, in Turkey, they would have handled with the prosecutor in a different way, which is also a serious breach in this context. But what I want to say is that there's a lack of political will in the Council. The Council does not want to activate Article 7 because, notice, just the first stage is enough for a state to be under stress and under pressure. So, to change its behavior. So there's a political question here. And I must also say, we don't need Article 7 at all. If you remember, and you go back to the year 2000, when in Austria, Chancellor Schussel, who was the head of the Austrian Popular Party, was the leader. And he had a coalition with the far right. At the time, President Chirac with Chancellor Schröder invited all the other countries, and they all did that to have a kind of quarantine against Austria. So there was a political declaration stating that they didn't accept that kind of government, and that they contested it. This created enormous pressure on the Austrian authorities. So even if there's no Article 7, the states could have applied pressure on Hungary and pressure on Poland. They just don't want to do it. I must say that I feel at ease to say this because the Hungarian party was in PPE. I think I contributed a lot for it to leave, but they were trying to leave from 2012, and then particularly as from 2016 when I thought it was an irreversible situation. But everybody is criticizing the PPE, especially the president of LIB. I don't know the name, I think Rita Veres, but that doesn't make any sense because it's a council. It's not a problem of political parties. Of course, they can do what they must do and should do. Unfortunately, they have already in the case of Hungary. But in the Hungarian and Polish cases, if the governments of each country did a declaration, as they did, we saw that they did now because of the issue of LGBTI rights. In the beginning of the summer, there were 16 states, not the Portuguese one, with the excuse that it didn't have the president, and it would never have. It is presided by the Michel. It's not by the rotary president. So it had all conditions to sign that letter. But 7 countries signed a letter that they didn't accept that violation of the LGTB rights, and said it was one more thing against the rule of law by Hungary. And what I'd like to make very clear is that it's possible to have political pressure. It's possible to apply Article 7, contrary to what he said, and especially Article 7, at least in the first stage, that would already create enormous political pressure, and it's possible to have political pressure. And what didn't exist over these last 10 years is the will to do it. And let me remind you that our Prime Minister, António Costa, on the eve, the day before of the European Council, that accepted to go into the market, which is from July 2020. In the eve, he went to Budapest and said he didn't want a conditionality of rule of law connected to European funds. This is his declaration, clear and simple. So the states stand on ceremony with one another. They are complicit with one another. They don't want to accept in the Council a very hard position. I think the situation we see in Hungary and in Poland nowadays, in the case of Poland, with enormous stress on the judicial power, greater than anywhere else. A true bullying, if we can say so, against judicial power. This only happens, and I'll end off with this, because there's no political will from the state. So 2 actions, lines of actions for future. Advance to the systemic mechanism of monitoring of rule of law, a bit like the European semester. In other words, every year have an assessment with consequences and recommendations for the states. And then, naturally, the activation or the compliance of Article 7, or at least the existence of a political pressure, which is enough. If a state feels completely isolated, it ends up giving in a way. So these are the 2 lines of action that I would say seem to have more possibility of success in the near future in the questions of compliance with the rule of law by the European institutions. But as I've said, both in one and the other. There's a lack of political will to move forward. Thank you very much.